Hi everyone, thank you for joining us today. Well, this is a work in progress presentation of Kayleen's and mine research. So we'll be very grateful for your feedback, for questions, observations that you can make, and this will be very helpful for us when drafting the full version of this paper. We are focusing on and the influence big data analysis enabled by the use of AI tools has on business to consumer relationships. Now, a number of issues arise in this context in relation to the nature and extent of data collection and use, the potential for bias or discrimination in algorithmic decision-making, and lack of explainability or transparency. Now, our research questions concentrate on the nature and extent of data and prospective insureds that can be lawfully collected and analysed, and consequently what harm to consumers can potentially occur. So we examine the rules currently in place and ask how they address the issues that arise.
Can everyone hear me?
Yes, yes.
Okay.
Well, at least I can.
Despite being around since the 1950s, the term artificial intelligence still, but I've got to give you some idea of the concept. It's best described as a field of study rather than anything single application or technology, but it produces and continues to produce a whole range of tools and techniques. A useful but still contestable description has been provided by the European High-Level Expert Group on AI. This description says that artificial intelligence refers to systems that display intelligent behaviour by analysing their environment and taking actions with some degree of autonomy to achieve specific goals. AI applications or systems can be purely software-based, such as a speech recognition program, or be embedded in both software and hardware, such as in autonomous vehicles or surveillance cameras with facial recognition capabilities. Now, on to another contestable term, big data. Most AI applications depend on the capability to process and analyse large amounts of data. For example, machine learning in particular requires large amounts of training data so it can learn to identify correlations and patterns and refine the models that it's using. In particular, big data is important for data-driven inferencing, where patterns are looked for in large, diverse and often changing data sets in order to classify individuals such as by their purchasing patterns or how risky their behaviour is. However, the mythologies that have arisen around big data analytics and inferencing can be problematic. Where this manifests, as it often does, in a tendency to believe that analyses and inferences created from large data sets are somehow naturally both objective and accurate. The reality is that the accuracy and validity of AI is heavily influenced not only by the programming, but also by the quality, complexity, availability, and origins of data.
Now, insurance is probably the most data-driven industry within the financial sector. Long before computers were invented, the insurance firms were already using data for the purposes of contracts underwriting. So no wonder they're turning so quickly to the technology available. Now, having said that, only some of the things we're going to mention today are already occurring, so mainly due to existing technical limitations. It is projected that the use of AI tools and digital process automation in general will have revolutionary impact on the insurance industry, however, only in 10 years' time. Now, these limitations may nevertheless disappear sooner than that, which means the sooner we'll begin to discuss the issues raised by the use of AI and big data tools in financial services and insurance industry in particular, the better. Now, huge amounts of personal data about consumers and their behaviours are generated every day, as Kayleen will tell us in a moment. So we are looking at how this data can be collected and used by insurers for the purposes of contracts underwriting. Why big data and AI tools are of interest for the insurance industry? So in very general terms, insurance works pooling risks, thus spreading the cost among all policyholders. Ideally, the premium a policyholder pays stems from the expected amount of risk that they bring to the pool. So underwriting is closely connected to risk modelling. Now, the more data is available and the better predictive analytics, the more accurate policy pricing can be offered. And the pricing, which is more precise in the terms of representing the expected risk, is better adjusted to the specific policyholder circumstances.
As Zofia's just pointed out, insurance has always been a data-intensive industry. Data has long surpassed any mandated disclosure of information customers must make directly to the insurer. Last year, for example, US financial services regulators reported that insurers have started looking for information on potential customers in their social media activities, their location tracking services, photographs, and retail purchase records. Digital platforms such as Google and Facebook are well known to harvest vast amounts of data from their customers. Less well known, but no less active, are the data brokers who aggregate, analyse, and on-sell data. Also, we are well into the first stage of significant socio-technical change relating to data collection in the form of the increasing number of data collecting devices that follow us down the street, come into our workplaces, live in our bodies. Smartphones are easily the most ubiquitous of these data collecting devices, but there are also smart TV sets and electrical meters, motor vehicles with embedded telematic devices, internet connected insulin pumps, street lights with facial recognition capabilities, and sensors that track where we live. As the use of these types of enhanced data objects becomes more widespread, this increases the likelihood that a greater quantity of data, and data which is more intimate and personalised in quality, can and will be collected and processed. One part of our research has concentrated on a data collecting object that's already fairly ubiquitous in Australia: rewards cards. Now, what's this got to do with insurance? You may or may not know that Woolies, which is one of the more common, also sells insurance, and that the Woolies Group also has a large stake in the data broker Quantium. Woolies has also indicated in the past that it was prepared to combine its insurance company data with its rewards database to determine which customers to target with insurance.
And with the help of our intern at the CLMR, Mr. Kayleen Jacob, we're conducting an empirical study into the privacy policies of various retail loyalty programs in Australia. So the aim of this study is to discover to what extent consumer data collected by loyalty programs may actually be used by insurance firms for the purposes. So currently, we have examined 4 loyalty programs in Australia, spanning the supermarket, pharmaceutical, and petrol industries. The personal information of different sources, and including purchases made by consumers or mobile phone applications. The information collected can be used for tailoring advertising, so-called operational processes. Further, all the loyalty programs studied had indicated that they may share personal information with unnamed third parties. Now, our preliminary findings suggest that there are a number of deficiencies within terms and conditions of the loyalty programs that may present significant privacy concerns for consumers. So first of all, the terms used are vague. So all the privacy policies were extremely vague on the information that they were collecting and the third-party sharing arrangements in place. So some policies indicate that they share information with so-called trusted partners, as Woolworths, whilst others only mention a non-exhaustive list of third parties. The second issue is cross-referencing. So the programs do not provide a comprehensive and aggregated privacy statement. Rather, they recommend that consumers should visit the websites of all related companies and trusted third parties for more information about their privacy practices and policies, which is understandably impracticable for consumers. And thirdly, many policies allow consumers to opt out of tailored marketing. However, this does not necessarily mean that the underlying personal information is not collected and not shared. And some policies, such as flybys, state that they may extract personal information about individuals from other members. Now, going back to insurance industry, is this a real possibility that consumers' data from external sources will be used for contracts underwriting? So although the real AI-driven revolution is coming, but it's not here yet. There is emerging evidence, and this is those are the examples that Kayleen, for example, used that from the US, that the insurance companies are already using individuals' private data for the purposes of contract underwriting. And no wonder they're doing this, as it is cost efficient in the first place. Now, let's imagine the insurer accessing a consumer's social media account. Now, they may use an algorithm that analyzes photos looking for evidence of someone, for example, smoking or eating healthy, like lots of veggies, or engaging in high-risk sports such as, say, paragliding. This is what a human would do. But now the technology allows the insurer to automate this process, which therefore becomes cost-efficient and worthwhile for the insurer, because they would definitely not dedicate human resources just to look through prospective insured's social media accounts. However, AI tools can potentially go a step further than just analyzing this potential insured's data looking for known risks. The algorithm can be fed and learn on the known risks that occurred in the past. This way, it may theoretically be able to find new, for example, still undiscovered or disregarded patterns in the data. And this, unfortunately, brings about potential for harm. The problem with algorithms learning on historical data is that if the data is not representative or it is biased in some way, the algorithm's output will also be biased. So there are more and more examples of this happening. There is a famous Amazon employment app that would favor men over women, or an Apple card, credit card in the US, which rejected women's applications more often than men. So, and in the insurance context, how such bias could operate is quite easy to imagine as well. Now, I'll be back to this discrimination bias issue in my second presentation. The so-called black box or explainability problem is another important issue connected to the use of machine learning algorithms in commercial decision-making processes. Sometimes the learning algorithm will produce an output where it is impossible to say, even for the software designer, how it has been reached.
There's also potential harm for consumers arising almost solely from the growth in data collection driven by the thirst of data-intensive industries like insurance. For example, with increased data collection, particularly of intimate data, come privacy concerns. As more data is collected and stored, the risk of a data breach increases. The potential for scope creep, where data is used for purposes not originally contemplated, or where it is seized by the state, is very real. Consumers also have ongoing concerns about how accurate data that's held on them is and whether they can correct it or have it erased. And just to point out to Andrew, there is actually no right to be forgotten in Australian privacy law, unlike in the GDPR. There's also concerns that corporate and state actors may use this data along with research into consumer behaviour to manipulate consumers to act in ways that are against their interests.
Despite important benefits, more precise risk assessment creates for insurers, as well as many insureds, a number of issues arise. So one of the consequences is that while many insureds will enjoy lower premiums, as more granular data will make it possible to evaluate the risk more precisely, some will face higher premiums or may be even considered uninsurable. And in some cases, the higher risk attributed to some insureds may not be under their control, although in other situations, the personalization of risk and pricing can incentivize consumers to adopt more prudent behavior. Now, a very good example of how greater granularity of risk can influence insurance premiums is the UK car insurance market after the ECJ ruling in case Testa Shah. So the ruling meant that from December 21st in 2012, insurance companies could not charge different prices for men and women. Until then, men were being routinely charged more than women. Interestingly, it was believed that the effect would be that some insurance companies could choose to increase the price of insurance for women in order to prevent discrimination against men. Now, the reality seems to be very different, though. In 2012, so just before the changes were introduced, men on average paid £27 more for car insurance policy than women did. And in 2016, that difference increased to over £100. And the reason is that once insurance companies couldn't ask for prospective insured's gender, They started looking at all the other available data and taking into account the risks attached to the person's occupation, how much they drive, the sort of car they drive, etc. And women in general tend to drive less, have fewer and less serious accidents, drink, drive less often. So insurers couldn't take gender into account anymore, but all these characteristics, yes. And this in turn translated into even more difference between average premiums for women and men. And the first set of rules that needs to be considered in the context analysed is privacy protection law. So our main question is if theoretically insurers in Australia can legally access consumers' data from various sources that we mentioned. And the answer, very generally speaking, is yes. Now, our study of loyalty programs' privacy policies aims at discovering in more detail how the privacy protection principles are observed in practice, and if the purpose of information collection allows the entities to use and share the information further. So, for example, we're looking at APP 6 on use and disclosure of personal information. So, interestingly, there is an exception to disclosure rule, which means it is allowed for personal information other than sensitive information to be disclosed to a related entity within the same corporate group. Now, this is why we're interested in loyalty programs with big supermarket chains, for example, as we know they do have insurance firms belonging to the same corporate group. And as Kevin's study is showing, they can freely share the information they collect on consumers. We have also observed that, generally speaking, privacy protection rules do not prevent firms from collecting consumer data through non-traditional sources. A question arises, protected. So this is another question. If information that is created through data analysis on the basis of the data collected. The concept of collecting information according to APP 3 applies broadly and includes gathering, acquiring, or obtaining personal information from any source by any means. So that includes collection by creation, which may occur when information is created with reference to or generated from other information the entity holds. And now, in this definition,
I'm going to have to hurry you along, please, Zofia.
Yes, that's it. Just the last thought. So the last thought is that this this definition bothers me because the new algorithms encode data in a form of tensors, of vectors. So the idea is that the data inferred from the input data is not materialized in the database. It might, but might not, be encoded within that tensor. And in some algorithms, it may be possible to track which parts of raw data are being assigned more importance by the algorithm, but it's not a universal feature of all those algorithms. So therefore, there is potential for inferring sensitive information and using it latently, encoded within a tensor, but without actually materializing or creating it. And this is the already mentioned explainability or scrutability program. Computer scientists themselves are looking at ways to make the algorithms explainable. However, it is not easy, as it may involve, for example, an additional layer of learning for the algorithm, learning how to explain its decisions, and is often more expensive as requires more computing resources. So the problem is therefore that there is no economic incentive for the firms to use explainable algorithms. Thank you. Sorry for...
All right, great. Thanks very much to both of you. So now we're handing back over to Zofia for her second presentation. And so, Zofia, if you'd like to take it away, and thanks to you, Kayleen, for this as well.
Thank you. And I promise that this second presentation is much shorter. All right, hope you can see the slide. So in our previous presentation, we looked at how data may be collected by the insurers. And in this paper, I'm focusing on how it can be used. So is the use of big data and AI by insurers compatible with the parties' duty to act with utmost good faith? Well, in this presentation, I provide some preliminary reflections in relation to the framework of rules that affect the insurer's freedom to use consumers' data for purposes of contract underwriting. So we'll be back to the privacy protection issue. So in the context of the use of consumers' data, there are two issues which are closely related to privacy protection and the AI bias risk. So as we said, the first problem relates to inferred information that does not materialize. So since we can't say if the algorithms base the outcome on a piece of information, a specific piece of information, it's very difficult to prove that it has not been biased. We just don't know if a person's, let's say, ethnicity contributed to the decision that the algorithm made. And here comes the second issue. It is raised that in jurisdiction where GDPR applies, for example in the UK, the firms cannot collect race, gender or disability data, and therefore they cannot run an empirical fairness assessment of the AI tools they're using. Therefore, we may suspect the algorithms discriminating someone because of their gender or race, but without transparent and representative data sets, it's very difficult to actually confirm it. And I'm just asking if such effect may be occurring in Australia as well. Regarding insurers' information obligations that are also relevant, a question closely related to explainability and accountability issues mentioned is if a consumer has the right to know what data influenced the firm's decision, and if there is right to correct that information that's being held about them. Now, APP 12 requires an entity that holds personal information about an individual to give the individual access to that information on request. But this only applies to personal information that an entity holds. And an entity holds personal information if the entity has possession or control of the records that contains the personal information. So we're basically back to the same problem. If we cannot point exactly to information that influenced the decision that the firm took, as it is latent information, not included expressly in any database, so can the entity be considered as holding that information? Section 75 of Insurance Contracts Act requires the insurer who rejects a potential insured, cancels a contract, or does not offer renewal or offer insurance cover to the insured on terms that are less advantageous than the terms that they would otherwise offer, to give the insurer a statement in writing setting out the reasons if the insurer so requests in writing. Further, the General Insurance Code of Practice states that the consumer will have access to information about them that the firm has relied on in assessing their application for insurance cover, claim, or complaint, again, if the consumer so requests it. So the same question, I believe, arises. Would it be enough to just indicate that this is following automated assessment of consumers' data without indicating specifically the characteristics the algorithm based its decision on? Now, we have to mention, but this is just to mention some insurers' other duties. Again, in the context of information duties, we need to take into account the product's disclosure statement. And another set of duties for the insurers will arise soon out of the unfair contract terms provisions that will apply to insurance contracts. But we'll skip that for now due to time constraints, and we'll focus a little bit more on the insurer's duty of disclosure and how and if the insurer's access to and use of consumers' personal data in the process of collecting and then processing of information using big data and AI technologies may influence the insured's duty of disclosure. And now we look at the issue starting from when the insured is not under a duty to disclose. So Section 21, subsection 1 of the Insurance Contracts Act gives a positive general definition of what is to be disclosed. And then this is modified by subsection 2, which lists specifically those matters that do not need to be disclosed, including a matter that the insurer knows or in the ordinary course of the insurer's business as an insurer ought to know. Now, if the fact that the insurer, say, accesses a consumer's Instagram account or data collected through a supermarket loyalty program would be understood as them knowing all these matters that can be inferred from their information, this could have important influence on the insurer's duty to disclose. Also, it would constitute an important incentive or barrier against collecting too much information about the insured, as the burden of analysing it and making sure it's relevant and complete would fall on the insurer. Now, obviously, this issue has not been tested in court. It is understood that the insurer is considered to have knowledge about the matter if it's known to an appropriate officer or agent of the insurer or contained in current official records. Now, it is true that there are cases in which it is stated that the fact that the insurer has access to some written information, as, for example, a newspaper extract in paper-based records, does not automatically mean the insurer has knowledge of the matter. However, I believe that digitalized information is a different thing altogether, and this may be considered as knowing. Another important issue related to the duty of disclosure is that in the the final report of the Royal Commission into misconduct in the banking, superannuation, financial services industry recommends that for consumer insurance contracts, the duty of disclosure on insureds be replaced with a duty to take reasonable care not to make a misrepresentation to an insurer. Now, the purpose of that recommendation is to address the knowledge imbalance between insureds and insurers regarding those categories of information which insurers consider to be relevant to their decision to underwrite a risk. And I think this imbalance is even more striking if we take into account insurers' access to consumers' data and possibilities of digital profiling. Is it fair that the insurer is able to avoid paying the claim on the basis of consumers' non-disclosure if the firm has access to all the relevant data? And even more so, if they use powerful AI tools that can discover patterns in the data that were not known previously? How could a consumer know what information is relevant to the risk assessment if even the firms themselves might not know this? And finally, we need to take a very quick look at anti-discrimination laws. So regarding the use of specific data, insurers are free to choose the factors on which they base the premium price in most lines of insurance, unless anti-discrimination laws apply. And if certain requirements are met, it is lawful for insurers to discriminate on the basis of age, disability, and gender, but never race. However, the provisions of the Anti-Discrimination Acts make it lawful for an insurer to refuse to provide insurance or to discriminate in respect of the terms and conditions of the policy if the discrimination is based upon actuarial statistical data, or in a case where no such data is available and cannot reasonably be obtained, the discrimination is reasonable having regard to any other relevant factors. And so my question is, can an algorithm used to analyze risk be considered any other relevant factor? And to basically conclude that, I think the problem with anti-discrimination laws, as well as insurers' information obligations mentioned previously, is that they require the consumer to take initiative and actively request explanation as to why they are denied insurance or the policy, premium, or cover is on less advantageous terms. So in order to act, the consumer needs to realize that they are being discriminated against. And this may not be obvious. So do you remember the Apple Card problem mentioned? Consumers realize the algorithm is treating women differently only because couples of husband and wife applied, and so that they were receiving different offers. And only after it was discussed on social media, such as Twitter, that people have realized that this actually may be a systemic issue. So if it didn't happen, people would not have this knowledge and people would not realize that they were actually being discriminated against. So there is therefore, maybe, I believe, a risk of market failure, as consumers may not realize that they are being discriminated against the algorithms used. And I know I'm running out of time, so I just stop there. I'm also taking a quick look at utmost good faith, but I don't see that there are straightforward solutions to the issues that we are analyzing. And so my preliminary conclusions are that, well, those algorithms are not yet in widespread use. So this is probably the moment that we should start looking at this with more attention. Thank you.